Good afternoon, everyone. Thank you so much for being here. My name is Kelly Beard, Content Specialist for Maryland Realtors, and I want to welcome you all to the Legal Forums update. I'm going to turn it right over to our Director of Legal Affairs, Kathleen Dartez, and Associate Counsel, Taylor Kitzmiller. Both will lead you in the discussion of what's taking place with updates, changes, and more. As a reminder, this webinar will be recorded and will be sent out to all attendees after the conclusion. We will also post it on our YouTube page. We encourage your questions and we look forward to answering them. Please post all your questions in the Q&A box below, and we will be answering them at the end of the session. And with that, I will turn it over to Kathleen and Taylor. Take it away.
All right. Thank you, Kelly. And thank you, everyone, for joining us this afternoon. We are going to do an hour-long presentation on our new and revised forms. We have some forms that are newly created, some that are revised, and you probably will be happy to hear some that are being retired. I'm Kathleen Dartez, the Director of Legal Affairs. Taylor Kitzmiller is going to be doing the bulk of the presentation today. He is our Associate Counsel and Staff Executive for the Statewide Forms Committee. Diamond Smith is on as well. She'll be chiming in. Diamond is our Staff Executive she's Associate Counsel as well, excuse me, and the Staff Executive for our Commercial Alliance and our Real Property Operations Committee. So I'm just going to take a few seconds and explain how the process works. I think many of you watching understand this, but just in case somebody doesn't know how it works, Taylor doesn't just come up with an idea and just go out and change the forms. That's not how it works. We do have a statewide forms committee. They meet on a regular basis. And what happens, I guess you all are practitioners. You help people buy and sell homes every day. You may notice that a form isn't being used the way it was intended, or that maybe there's a situation that's occurring in today's market that we don't have a form for. Those type of situations come up. So what happens, you would bring that to my attention, Taylor's attention, or Diamond's attention, and we will put those, we put them in a little folder. And then when Taylor is creating the agenda for the next meeting of the Statewide Forms Committee, the committee will meet and discuss those suggestions and, either approve them or not approve them. Then it goes to the executive committee. The ones that were approved goes to the executive committee for approval, and then it comes back, and then the forms are created. And again, the committee reviews them again, outside counsel reviews them, and then that's when the forms are released finally. So that's the process. And just keep that in mind as you go through the year, as you're entering in transactions and representing people in transactions. If you see something that isn't working properly, if you have a suggestion that you think might help things work better, please reach out and feel free to share that with us, and we'll be delighted to bring that to the committee. So I guess let's go ahead and get started. I'm going to pass the baton to Taylor, and he can start talking about the new forms that have been created.
All right, great. Thanks, Kathleen. All right, let's get into the new forms here. We have 9 new forms this year. Some are pretty substantial, but I'd say about half are pretty straightforward. And our members should be used to probably using about half of these forms. So to start off here, we have the exclusive commercial buyer-tenant representation agreement. If you remember back in October of 22 last year, we came out with the commercial property exclusive listing and commission agreement for our members to use when representing a seller of commercial property. However, we didn't have a form for the opposite side of the transaction when you're representing a buyer or a tenant of commercial property. So now we have created this new representation agreement for our members to use when they're representing a buyer or a lessee of commercial property. Our members should be very familiar with the majority of the terms of this agreement because it's modeled after the exclusive buyer-tenant residential brokerage agreement. And we actually sent this agreement to our Commercial Alliance Committee, and they supplied their input. Their commercial practitioners specialize in the area. So it was great to get their input as well. And I will pull up that form just as a kind of a plan of action for this presentation. I'll go over the PowerPoint, pull up the corresponding form, and I'll touch on some of the highlights of the forms, parts that I think are pretty important. Like I said, everybody should be very familiar with the language of this form, as it's almost identical to the residential buyer tenant representation agreement. Really, the only main difference is this disclosure at the top, basically stating that this should only be used by practitioners with experience in commercial real estate transactions or who are under the supervision of an experienced commercial real estate practitioner. As commercial real estate practice is a little more specialized, and you need to have that special skill and knowledge in order to represent a buyer or a seller in a commercial transaction.
And don't be afraid to make a referral if you do not have that experience. We have
Right.
a lot of experienced commercial practitioners, so just going to throw that out there.
All right, our next form is the assumption addendum. And you'll see it's a common theme for this form update, these forms updates. We referenced the assumption addendum in our contract of sale. However, such an addendum did not exist. We didn't offer it. So we would get calls quite often, asking about a certain addenda that's listed on the contract of sale, but we realized that we actually didn't have that addenda to offer to our members. So an assumption addendum was one of those. And so we've created it, and now it is to be used when property being sold has an existing mortgage and the buyer and the seller are agreeing to allow that buyer to assume and take over that mortgage as a part of the purchase of the property. And it's subject to the lender's approval of that buyer as well. Just some notes here. The lender holding the existing mortgage may require the buyer to submit an application to prove that buyer's creditworthiness and ability to assume the mortgage. And also the seller's liability to pay the existing loan assumed by the buyer will continue unless the seller obtains a release of liability from the lender or loan servicer. So I'll pull that addenda up now. So it's pretty straightforward addendum. It is only 2 pages long. First section here just goes over what the existing loan is. So you have the approximate loan amount, the current interest rate on the loan, how much the loan is per month. Then down here, it addresses, like I referenced, the application. If required by the lender, the seller will provide that application to the buyer within a certain amount of days. And then the buyer will submit that application. If the buyer is not approved, once they submit that application, then the buyer has the option to terminate the contract of sale, or they can seek alternate financing as well. Second paragraph here just goes over some requirements that can be set by the buyer. So the buyer agrees to pay any assumption or transfer fees so long as they don't go over X amount. And also the buyer agrees to pay any interest rate increase so long as that does not exceed a certain amount as well. Really, all the other paragraphs are pretty straightforward. We have a paragraph in here addressing a VA loan if it's being assumed. For a VA loan assumption, the buyer has to use certain forms. We have those 2 forms laid out right here, just putting the buyer on notice that they have to use certain VA forms if they want to make that application to assume the loan.
I would just chime in and just say, for people who've been in the business for a while, they might be familiar with assumption agreements. If someone who's maybe newly licensed maybe hasn't been through this sort of phase in the market before, but it's in the past, we would see more assumption agreements when interest rates were rising. If the seller's current mortgage is at a relatively low interest rate and the buyer is going to have to go out and pay a much higher interest rate to purchase the property, that's when they would talk about assuming the existing seller's loan, taking it over at that lower interest rate. So we may see more of these. I guess we're ready if we do, and it might vary from lender to lender, but that's at least the framework for it there, and gives the buyer some options and the seller some options as well.
Great. Thanks, Kathleen.
Sure.
All right, moving forward. This is the Foreign Investment in Real Property Tax Act Addendum, otherwise known as the FIRPTA Addendum. Oops, sorry, I let one out. Again, this is an addendum that was referenced in our contract of sale. However, we did not offer such an addendum. And the purpose of this addendum is to put the buyer on notice that FIRPTA applies to the transaction. And I'm sure many of you are saying, what is FIRPTA? I've never even heard of it. It's not ringing a bell for me. So I'll kind of explain it here a little bit. So under FIRPTA, which is a regulation set by the IRS, if a buyer is purchasing a property that is listed for, or that sells for $300,000 or more, and the seller of that property is a foreign person as defined by the IRS, that buyer is responsible for withholding income taxes from the amount realized, basically the purchase price, at settlement. And the reason why this regulation is put in place is because Uncle Sam always wants his cut, always wants to ensure that he can get his taxes. And if a seller is a foreign person, it could be possible that that seller could, skip town and go back to whatever country they're from, and the United States government would not be able to collect those taxes. That's why in a transaction like this, the buyer is responsible for withholding a certain amount from the purchase. I'll pull up the addendum here. Again, this is a very straightforward addendum. The top portion here just goes over exactly what I just touched on, explaining what a FIRPTA transaction is. The seller is disclosing to the buyer that they are a foreign person, and FIRPTA is applying to this transaction. Paragraph 2 here. So a seller can be exempt from FIRPTA as long as they apply for that exemption and the IRS issues an exemption certificate to that seller. And this paragraph is basically stating that if the seller is claiming an exemption, then they must provide the buyer with an exemption certificate within a certain amount of days from contract acceptance. So yeah, pretty straightforward addendum here, just putting the buyer on notice saying, hey, buyer, this is a FIRPTA transaction and you're going to have to make sure you withhold a certain amount from the purchase price at settlement. All right, moving on, our Forest Conservation Act addendum. Again, this was referenced in our contract of sale, but it did not exist. The seller should use this Forest Conservation Act addendum to put the buyer on notice that the property is currently subject to a forest conservation plan, which may restrict that buyer's use of the property. And just a summary of what exactly, the Forest Conservation Act is and a forest conservation plan is. So basically, the Forest Conservation Act states that if there's any activity which requires an application for a subdivision, grading permit, or sediment control, basically construction on the property of 40 square feet, which is approximately 1 acre. So property that's 1 acre, and you want to do, let's say, a grading permit, you are required as that owner of the property to get a forest conservation plan put in place. So you have to reach out to I believe it's the Maryland Department of Agriculture, or I believe it's the Maryland Department of Environment, actually, and explain, what you're going to do with your grading permit, and they will provide to you a forest conservation plan, which essentially states how or what you need to do in order to replant trees, basically to restore the property in the environment roughly in the same shape as it was before that construction was performed. So I'll pull up the addendum here. Again, another short and sweet addendum. Top portion just explains exactly what I said, what the Forest Conservation Act is and what a forest conservation plan is. And this is just the seller putting the buyer on notice that the property is currently subject to a forest conservation plan. Seller has to deliver that plan to the buyer within a certain amount of days. The buyer has a review period. And if the buyer is unhappy with that forest conservation plan, unhappy with how it restricts their use of the property or its requirements, the buyer can terminate the contract of sale and notify the seller of that termination. All right, I'm going to hand it over to Kathleen to go over next couple addendum.
All right, thanks, Taylor. The owner financing contingency addendum, I believe this was another one of the in the contract, the list of addenda that were listed there but did not actually exist. So Taylor has done a great job of tightening that up. So when you see something listed there will actually be an addendum now moving forward. So this was one of them. What it is basically where the owner can offer financing to the buyer. Again, we might see more of that in this market. I'm not entirely sure. I guess you guys have a better feel for that. But it has been offered as an addendum for a long time. We finally created the actual addendum. What it would be is basically, I guess the way it's structured or set up is that the buyer would be making payments to the owner rather than to a bank. That's generally how it's set up. I think something to pay attention to on this notes comment up here. This is, drafting loan documents is not providing real estate brokerage services. So you want to be careful what you're doing here. You can help your people complete this form. It's basically a structure and a process to help them work through the process. If there's going to be owner financing, the buyer's agent should not be drafting these documents. The listing agent should not be drafting these documents. The seller should be consulting with an attorney or someone to draft the documents for them. Taylor, you want to turn to the document itself, and we can kind of walk through it a little bit? Yeah, so the way this is set up, the owner has to be willing to do it, first of all, right? So the owner's going to offer seller financing. Yes, I'm able to do that. I'm willing to do that, right? So the first paragraph here, the parties would basically come up with some basic agreement, what the terms of that loan are going to look like, what the principal balance is going to be, what the interest is going to be. Is it going to be, have a balloon payment due in 5 years or whatever that is, sort of some basic terms in that first paragraph there. The second paragraph is, if the seller wants to make a loan to a buyer, the seller essentially is a lender, right? And like every lender, you want to look at the buyer's financials, right? Their ability to repay the loan. Are they going to be able to repay it? Do I want to make a loan to this buyer, right? So the buyer is going to provide requested information to the seller. They're going to negotiate the time frame, right? How long the buyer has to provide those documents to the seller. The seller can request tax returns as well. They can agree on that. The buyer will provide tax returns, or the seller maybe doesn't care about that. It's not going to ask for that. Also a credit report. Again, the buyer is going to provide seller with a credit report. Basically all the documents that would be relevant to the seller to review the buyer's finances and see if they find this buyer to be creditworthy, if they are willing to extend credit or make a loan, make the mortgage loan to this buyer. If the seller, the next paragraph, if the seller reviews the buyer's credit documents and says, not happening, the seller can terminate by delivering a unilateral notice of termination. Again, that's going to be the seller's decision, the seller's call. I've looked at these documents. You have an open bankruptcy. I'm not going to make a loan to you, that type of thing, right? So the seller could terminate. Or the second option there, if it's something relatively minor and the buyer and the seller could work it out, then they could resolve it. That's an option there. If they're able to resolve it, then it would move forward. The next is 3.1, I guess. If the seller does not cancel the contract and they're not able to work it out, then the seller will have waived their right to cancel the contract pursuant to this addendum, right? So the next paragraph here, the credit documents, that's going to be what documents the seller is going to be looking for. A note, a deed of trust would be typical. They could do a mortgage as well. We don't see that too often here in Maryland, but I guess they could do a mortgage if they wanted to. Again, the seller would be seeking advice of counsel, having somebody else draft those documents. You're not going to go to 1-800-MORTGAGE-RUS or mortgagerus.com and give them sample forms. They're going to consult with, qualified counsel to draft those documents, right? The next paragraph, seller is going to pay for and be responsible for creating the documents. And again, the next paragraph, the parties are going to negotiate the time frame where seller is going to provide those documents to the buyer. And then the next thing I think is sort of common sense. The seller has given these. This is the way I want the loan to look. This is what I want it to say. The buyer is going to have an opportunity again to review those documents and decide if the buyer can live with that or if the buyer wants to terminate, right? So the same type of thing. The buyer has two options. The buyer can either cancel the contract of sale with a unilateral notice of termination, or they can resolve in writing any objections. They can basically negotiate and try and work through their objections. And again, the buyer may or may not want to consult with an attorney on that. Probably a good idea. If this is going to be a loan, there's interest involved. There could be, possible foreclosure if they're not able to make their payment. So the best advice would be for both parties to consult with an attorney. Again, the same option here. If the buyer doesn't cancel the contract or resolve the issues, then the buyer is going to waive their right to cancel based on this contingency. The next paragraph here, title insurance. Again, the seller basically is stepping into the shoes of a bank and acting in the capacity of a lender. So the parties can negotiate whether the seller is going to request a copy of lender's title insurance. And then again, the last paragraph here is just disclosing tax ID numbers. Again, you guys know some people are nervous, justifiably nervous about exchanging their social security numbers and that type of information. But in order to get this and to do the, I guess, determine the buyer's financial wherewithal, I think the seller is going to need that information. So the parties just agree that they are going to exchange that information. They understand the obligation to provide that. Information has to be reported to the IRS as well. So the seller's going to need that information from the buyer. And then there is space for additional turns if that's necessary. All right, I think that's it, right? Move on to the next one. All right, financing. Seller's home of choice. This should make everybody happy. Everybody's probably clapping now. That was another one of the addenda that was listed on the form but did not exist. I think particularly in the market that we've had over the past couple years, with a shortage of inventory, seller may be selling their home. They want to purchase a new home. Sometimes that isn't as easy, or something falls through. They may not be able to get their home of choice. So this is a contingency that you would use if the seller is not going to go forward with the transaction unless they find their home of choice, right? And it's you can see on the notes there, basically the form, we paralleled pretty closely the existing form for the buyer, where the buyer has a contingency. The buyer has to sell their current home or enter into a contract to sell or go to settlement or lease, whatever, a couple of different options. When we look at the actual form, you'll see that this new form, seller's home of choice, tracks those options pretty well. I'm going to turn to the form now, Taylor. All right. Yeah, there's seller's home of choice. I think at some point, I think we're going to mention too that we changed the name of the other form. It didn't say buyers previously. So now this one will say seller. The other one will say buyer to make it, oh, what's going on here? Make it easier for you guys to find the forms. Okay. So again, like I said, it parallels the other form. The buyer and seller are going to make, they have choices here. This contract is contingent upon seller entering into a contract of sale on or before a certain date. Buyer and seller will initial A. It could also be contingent upon the seller receiving financing commitment for the new home they're trying to purchase on or before a certain date. Again, buyer and seller would initial on the margin over there to indicate that's their option. They're agreeing to that. Or the C, they can choose this as well. This contract could be contingent upon settlement of seller's home of choice on or before a certain date. You're not just going to be satisfied with the seller having a contract. Seller might be nervous, that might fall through. The seller's going to say, I really don't want to move forward with selling this home until I am absolutely sure, until I have settled on the other home and I know for sure that that's happening. That's one of the options. That's going to be C1. The parties would initial to the left there. Or if the seller is willing to lease a property, that's another option as well. In that case, they would put the date in number 2, C2, and the parties would initial that in the left-hand margin there as well. I think that is pretty much, again, if this doesn't happen, if the seller is not able to enter into a contract or not able to settle, or whatever options they have agreed to, then the seller can terminate the contract. Notice has to be provided to the buyer, and then the deposit is handled, consistent with the deposit paragraph in the contract. All right, I think that is it for that one.
Mm-hmm.
And then these, I don't know if we need to go through all 3 of these, but you guys will notice, many of you have brought this to our attention. I shouldn't name any names, but Linda Harned hounded on this pretty much constantly. Some of the inspections, the property inspection addendum addresses certain inspections, and the property inspection notice, which some people refer to as the PIN, it was intended to address those specific inspections. There were also some forms for additional inspections that are kind of special inspections or a little bit different that didn't fit into that framework as readily. The way it was previously, we had the inspection addenda but we did not have a notice. If the buyer wanted to ask the seller to take care of anything or any issues were identified during the inspection, there was no process or time frame for the buyer to ask the seller to do anything or for the seller to respond. So you will be happy to know that we now have created a notice for the on-site sewage disposal system, the water quality, and the water yield tests. All of them now have corresponding notices that you can use as the buyer's agent, and you would respond to as the listing agent regarding any requested repairs or discrepancies or items that the buyer wants the seller to address for those three inspections. So let's pull up, why don't we pull up the first one?
Yeah, we'll pull
I don't know if
one
we
of
need to
them.
go through all three. Yeah, this is the on-site, the OSDS inspection notice. Again, the same language that's on the other form. This is not, it's really just supposed to be addressing issues that came up during that inspection. It's not to ask about routine maintenance type things or, you know, anything that's cosmetic, right? That's sort of the scope of all of these inspections. So this notice is, the scope here is limited. It pertains just to the OSDS inspection and test addendum. Buyer is going to notify the seller. A would be the best case scenario. No problems. Everything's great. I'm not going to ask you to do anything. Yes. The second one is if there are issues that the buyer would like the seller to address, the buyer will provide a copy of the inspection report, provide that to the seller, and identify what items they want the seller to take care of. The buyer is going to sign, date that, and then the seller is going to have a time to review that and respond. That's on the next page. Can slide down there. Yeah, the seller's going to respond. So seller says, great, I will do everything that you requested. And buyer basically will, you know, doesn't have to respond. The buyer just says, thank you, awesome, right? Or the seller can say they are not going to complete those repairs. And again, this is the seller's response. I'll take care of everything. I'm not going to take care of everything. Seller will initial, seller will date. And now the ball is back in the buyer's court, and the buyer can say, I'm going to accept your response. I am not going to make those repairs, or I am going to accept your response and, you know, you're not going to make those repairs. I'm okay with it. I'll take care of those repairs. I'm going to move forward with the transaction anyway. So those are the options available to the buyer there. All right. And I don't think we need to walk through the other ones, but like I said, the water quality test notice, the same thing, same options. Basically, it contemplates a back and forth. Buyer gets the test results. Buyer can ask the seller to take care of things. The seller can say yes or no, and then buyer can either live with that or terminate the contract, basically. Is that, did I oversimplify, Taylor?
No, you did a great job. And the water yield tests, so basically all these forms are almost identical. It's just what corresponding inspection, you know, they're addressing. So
Right.
it's the same for the water yield test notice as well.
Okay.
All right. Okay. So that wraps up all of the brand new forms that we have coming out this year. Now we'll move on to some of the revised forms. Again, not a huge list here. Most of the changes were pretty minor. So the first change we made was to the consumer notice to buyers of residential real estate in Maryland form. And we made this change in response to House Bill 107 that was passed, a new change in the law, which requires condos and HOAs to update the reserve study every 5 years or conduct a new study by October 1 of this year if no prior study had been performed. So condos and HOAs who have never conducted a reserve study may now have to collect a large amount of money to fill their reserve fund. And for those of you who don't know, essentially what a reserve fund is a lump of money that a condo or HOA needs to have on hand at their disposal to do things like make repairs to the common areas, to make structural repairs, basically make sure the condo or the HOA is in working condition and is in a safe state. So now to meet that funding requirement, who's going to pay for it? It's going to be the residents of the condo or the residents of the HOA, and that will likely increase monthly dues for the residents, or also special assessments can be imposed on the residents as well. So the condo/HOA reserve study disclosure paragraph was added to the consumer notice to buyers of residential real estate. form, and it essentially warns buyers of this potential increase in dues or special assessments that could happen, and it tells them to pay extra attention to reserve study reports from the condo or the HOA that they're looking to purchase. And really, the main reason why we created this disclosure was to protect you guys, to protect our members from a situation where, let's say, a buyer purchases a new condo or purchases a condo, this year in October, and that condo never did a previous reserve study. They performed that study, and now that condo has to collect, $50,000, $100,000. And now that buyer's monthly dues are going to skyrocket, or they might get a special assessment. And now we kind of predicted a scenario where buyers come back to that agent and say, "Hey, agent, you didn't warn me of this. Why didn't you?" and blame the agent. But now, since we have this disclosure in the consumer notice to buyers form, where you'll present to the buyer, they will sign off on it. You can say, "Listen, we made this disclosure to you, and it was on you to make that review of the reserve study." And also, just another note here, the consumer notice to buyers form should always be included with the exclusive buyer tenant representation agreement. And I'll pull that up really quickly. It's a very minor change. Again,
I'm going to jump in just for 1 second and just say, if anyone has any questions or wants more information about the reserve studies, we did a webinar on that, and all of our webinars, we have a YouTube channel. All of our webinars are shared on our YouTube channel afterwards. So if you didn't have a chance to look at that or listen to that webinar and you have questions, it was about an hour long, and there was someone from the state of Maryland was there. We had a property manager there and a lender there. So they went into a lot of details about the changes in the law. So that's a good resource if you didn't have a chance to check that out yet.
Great. And yeah, here's the change. Like I said, small paragraph explains what a reserve study is. And you'll see here, buyers advised to pay close attention to the reserve study report of a condo/HOA, as an underfunded reserve fund may result in a future increase in dues, HOA fees, or a special assessment upon the buyer. All right, moving on. We made a change to the escrow agreement between buyer, seller, and escrow agent. We changed the distribution of deposit paragraph, and we made this change in response to the passing of Senate Bill 651, which is a new law which addresses a new release procedure for earnest money deposits. And specifically, this new law addresses a new procedure only when the buyer is terminating the transaction pursuant to a contingency as defined, and that contingency is defined in the statute. A note here, and I'll show and explain that new deposit procedure, but a note here, the old release of deposit procedure still remains in effect, as that release of deposit procedure should be used when either the seller terminates or the buyer terminates, not pursuant to a contingency. All right, so here's the escrow agreement. We have the distribution of deposit paragraph. So the first section addresses the old release of deposit procedure, which you're all familiar with. So if a buyer is not terminating pursuant to a contingency, or if a seller terminates, then this is the old language, the old release of deposit procedure that the holder of the escrow deposit had to follow. Now, this is the new deposit release procedure. So if the buyer terminates pursuant to a contingency, the buyer may request the return of the deposit by providing the escrow agent and the seller with a written notice of that request. Within 10 days after receiving the request, the seller may provide the escrow agent and the buyer with a notarized written request for mediation relating to the distribution of the deposit. If the seller does not deliver that notarized request, for mediation within that 10-day window, then the escrow agent shall return the deposit to the buyer within 30 days after receiving that initial request for the return of the deposit from the buyer. And if the seller does, deliver that notarized written request for mediation, then the escrow agent shall hold the deposit until a mediation agreement authorizes the distribution of the deposit, or that escrow agent files an interpleader action in court. Now, some things of note here. This new law applies to both title companies, typical escrow agent, as well as brokers. So if you're a broker, you're holding a deposit, and let's say a buyer terminates pursuant to a contingency in the contract, then this is when this section applies, and that seller needs to make a request for mediation within 10 days, or the buyer is going to get the return of that full deposit. And just the kind of the reasoning and the purpose behind the passage of this law was we've gotten calls on the legal hotline all the time, and it's a common issue where a buyer will terminate the contract pursuant to a contingency. So let's say, for example, during the review period for an HOA property, I believe that 5-day review period states the buyer has the right to terminate the contract pursuant to that contingency. Under the old release of deposit procedure, the buyer could terminate and request that EMD, the return of the EMD, but unless that seller signed off, that EMD just sat there, and whoever's holding it could not release it until, again, a mediation agreement was put in place, or that escrow agent filed an interpleader action in court. Now, this new law really puts the pressure on the seller to make that request for mediation within a pretty limited window here, 10 days. And if they fail to make that request, then the buyer will get the full return of the EMD. Kathleen, do you have anything to add there?
No, I think that's good. I think everybody is, I'm sure, generally aware that the way that the deposit law worked previously, honestly, it wasn't great for buyers. Even if, as the example that Taylor used, if someone terminated the contract based on the condo documents or the HOA documents, the statute says the buyer is entitled to get their EMD back, but the Brokers Act said the broker couldn't disperse the EMD until they have something in writing signed by both parties. So a stubborn or difficult or angry seller could slow the whole process down by just not agreeing that the EMD would go back to the buyer. So that's I'm sure everyone watching this has had that situation come up, and that really is what this is intended to address. The seller will no longer be able to do that when the buyer terminates pursuant to a contingency, as Taylor had indicated. So the seller has the obligation, if the seller doesn't want the money to go back to the buyer, the seller needs to step up within 10 days and file a request for mediation. Let the broker know, the title company know, do not disperse that money. We are initiating a mediation. If the seller does not do that within 10 days, then whoever's holding the money, the title company or the broker, is going to cut that check within 30 days and get it out. So I think it'd be much better for buyers, make it easier for them to purchase their next home. Most buyers, especially first-time home buyers, need that EMD back before they can move on to home number 2. So I think this seems to be pretty popular. I mean, I don't know if anyone cares about our personal opinions. Personally, I like it, but we'll see. I hope this will be beneficial to buyers.
All right, great. Let's move on. We made some minor revisions to all of our listing-related brokerage forms. We had the wire fraud disclosure in the buyer representation agreement. However, we didn't have it in the listed related brokerage form, so that wire fraud disclosure has been added. A recent bill, Senate Bill 579, was passed, and it limits the listing term for a listing contract to only be 1 year in duration. It can't be longer than 1 year in duration. So we've made that note in all of our listing related brokerage forms that the listing term or the term of the contract cannot be longer than 1 year in duration. And finally, we added the FIRPTA Addendum to the exclusive right to sell residential brokerage agreement. Just so if you're meeting with your seller and your seller's a foreign person, they're selling their property for over $300,000, then they can check off that FIRPTA box, and then you can have them execute that FIRPTA addendum at that same time that they're executing the residential brokerage agreement as well. Again, the exclusive buyer tenant residential brokerage agreement, we made that same change, addressing the term of the agreement can no longer be longer than 1 year in duration. The general residential dwelling lease template was changed in accordance with House Bill 102. So House Bill 102 was passed, and essentially it requires a lease for a residential dwelling to have a link to the Maryland Department of Agriculture's website, where that tenant can follow that link, and it's a tenant who is facing eviction or loss of possession of the property. They can follow that link, and it will take them to a flyer with information on how that tenant can provide temporary or permanent housing for their pet. So, I don't know. We're not very concerned about the tenant who's actually being evicted or, losing possession of their property, but we needed to include this in the lease so they know where their pet can go stay during the meantime or permanently. So yeah, it's a new paragraph. I guess I'll pull it up really quickly.
I would just say, anyone, if you guys do property management for a landlord, I mean, we have a sample template that can be used if you represent a landlord who has their own lease form. This would be good information for you to share with them. They would want to include that with their, update their lease form to include this language.
Right. So the paragraph is called pet protection during eviction / loss of possession of property. And it explains, if the tenant's evicted, they can go to this link and it'll take them to the flyer with the required information on where they can provide housing for their pet. The post-settlement occupancy agreement, the term of occupancy and consideration paragraph was modified to specify the exact time of day for when a seller must vacate the property. And I'll pull it up really quickly because it's just easier to see. So before, it just stated the date upon which the seller had to leave the property. However, we had some concerns from our members about sellers not leaving at a certain time, and the parties arguing over what time of day the seller had to leave the property. So now the parties can state specifically, 1 p.m. that seller has to be out of the property. The residential contract of sale, only a few minor tweaks here. So the deposit paragraph has been updated to reference that new release of deposit procedure. The new addenda, the FIRPTA and the Forest Conservation Act addenda have been added to the list of addenda as well. Also, as Kathleen referenced before, previously the sale, financing, settlement, or lease of other real estate, that was what it was called in the contract of sale, but we have changed that to be the buyer's sale, financing, settlement. So to more accurately title that as it's a buyer's form. And also the reference used to be just to a home of choice addendum, but now we've made it the seller's home of choice to more accurately label that addendum. The unimproved land contract of sale, we made a slight revision to paragraph 26 as to a new contingency for whether the property can connect to the public sewer system. I'll pull that up really quickly. So again, this is the unimproved land contract of sale. This is paragraph 26, multiple contingencies here. So whether or not the property is suitable for private on-site sewage, whether it can connect to public or private water, but we did not have a contingency for whether or not the property can connect to the public sewage system. So we just added that contingency. in here to go along with all the other contingencies. And finally, our retired forms are all of our COVID-19 related forms. Hopefully we will never need them again, and we can say, good riddance to them. All right, so those are all of our new forms, all of our revised forms, and the retired forms. I guess we can, let's see, Q&A.
We've got some questions. I think we can answer the questions. Maybe I should ask Kelly just to jump in. I believe some people had asked if they could have a copy of the slide deck. I believe that we provide that to everyone who has registered. So everybody should be receiving a copy of that. If you want a copy of this actual recording, we do record all of our webinars and we do upload them. They go to our YouTube channel. So that, it may not happen this afternoon. It might take a couple of days, but if you want to watch this again, or if you're a sales manager, if you want to use this for a sales meeting and, show this to your agents, you can pull it from our YouTube channel and share that anytime, anywhere. Okay.
Yep, and you're correct, Kathleen. So anybody who registered for this webinar will get both the slide deck and the video. We are going to tab the video so that we have markers for the new forms and the updates and changes so that you guys make it easy for you. So it may take a few days, but you guys will be getting that via email. And then it will also, for future reference, be on our YouTube page. So we'll share that in the email as well.
Okay. All right. Thanks, Kelly. All right, so we can maybe go through some of these questions. There's a lot of that knocked out a couple of them right there.
There we go.
FIRPTA, is it a purchase price of $300,000 or net proceeds? It's generally the purchase price of $300,000. So that's a good question, and pay attention to that, you guys. You don't want to be surprised at settlement to realize that there's going to be a withholding tax or taxes that have to be withheld. So that is on there. I would say also for the FIRPTA, I know we have a couple of title people on here. I saw Drew from Sage Title, Drew Kelly's on. I know a couple other title people are on. Feel free to reach out to your title company. They deal with FIRPTA all the time. They can explain the nuances and the details of how that works. And they actually would be assisting with the paperwork and need to know whether the seller is going to be subject to FIRPTA or not. So definitely reach out to your title company if you have detailed questions on that.
The Forest Conservation Act addendum. So when is it necessary? If the property is currently subject to a forest conservation plan, the forest conservation plan is in place and it is, setting requirements for anything that's going on the property, that's when the seller would use the Forest Conservation Act addendum to say, hey, buyer, this property is currently subject to a forest conservation plan. Here is, a copy of that plan, and the buyer has a review period to decide whether or not they want to move forward.
Somebody just commented that there was a complaint filed with the Real Estate Commission about special assessments. So, and I don't want to, our job is not here to scare people or frighten people, but we are here to provide information so you can be prepared and give your clients relevant information. So again, that other video goes into the other webinar goes into a lot of detail, but the reserve studies could be a big deal for condos or HOAs who have never conducted a reserve study. They're going to have to do one by October 1st of this year. It's going to say a dollar amount. Your association needs to have this much money in reserves. The association has 3 years to get to that point. If they don't have any money available right now and they need to get to a high number in 3 years, we all can do math, divide that by the number of unit owners or lot owners. The dues are going to increase, or there could be a special assessment imposed. So make sure that your buyer clients in particular are aware of that. They read that, they ask the right questions. It's a transition period right now, so there's not great answers sometimes. But you do need to be aware of it. That sometimes the best we can do is make our clients aware of a situation, give them the information that we have, and then they're going to make their decision. And, by 3 years, this will all have shaken out. The money will be available in all of these associations, let's hope. But there is a transition period. So definitely pay attention to it in condo and HOA transactions. Make sure your buyer's aware of that. If the associations have done the reserve study already and have collected the money, it's not as big of a deal, hopefully. But for ones who've never conducted the study, those are the ones you're going to have to be careful with, because it could be a big jump in the dues, or special assessments could be imposed as well. Okay, what else do we have? The 10 days start from the release. What's it? Does the 10 days start on the date of the release request or the next day? I think there's a paragraph in the contract, but generally, anytime something is requested, within a 10-day time frame or whatever it is, it generally day one is the day after the form is sent. Did I explain that well? Taylor, you want to clarify that? I think that's okay, right?
Sorry, I was trying to find where you're looking in the chat.
Corey Robinson. Okay, do we have a notice from the buyer to request a deposit back for termination based on contingency? That would still be, we have a release of deposit form. The existing form could be used for that. I think that would be the same form could be used. Did our EMD? All right, can we share the slides in the new forms? Yes, we're going to share the slides in the new forms.
The buyer has yet to put their home on the market. Should the buyer and seller check A, B, and C on home sale contingency addendum? So it's up to whatever the buyer and seller agree to. They can choose A, B, and C, all three options, or they can choose just A. They could choose A, B. So it's up to the buyer and seller to agree on how many contingency options they're going to agree to.
Right. Where would one go to verify if one is a foreigner? What should the seller have? Basically, the that's for a FIRPTA question. It applies if someone is not a U.S. citizen or permanent resident, a green card holder. So the seller should have that information. My parents were both foreign born, so foreign person I think is a little awkward wording, but that is actually the wording exactly from the IRS statute. That's the exact phrasing that they use. So we tailor copied the language from the IRS code so it matches perfectly. But the seller would have that information. The seller would know. And again, like I said, for more detailed questions, I suggest talking to your title company folks. And we do have I see Jill Michaels on here as well. We have quite a few title people on here.
Kathleen, we addressed this the other day. The question is, on the listing agreement with extensions signed, could it be longer than a year?
Yeah, the way
I answered.
Are you?
Oh, is that answered? Okay. Yeah, that's just in general for everybody. That's a good question. The bill that was passed, it limiting the term of brokerage agreements, basically, or agreements to buy and sell homes. There was a lot of action or a lot of activity, I guess, nationwide. There were some companies that were making loans, I guess, offering loan to homeowners and then asking the homeowners to sign agreements. And these agreements were getting recorded in the land records. People were just referring to them as 40-year listing agreements. And a bunch of attorney generals through states throughout the country were sort of dealing with these. And a lot of state real estate commissions were dealing with these, sort of a consumer protection issue. So what happened here in the state of Maryland, it was the Attorney General's Office, the Consumer Protection Division, I think, looked into this. And there is some guidance from the Maryland Commissioner on Financial Regulations. They gave very detailed guidance on this. And basically the requirement that affects all of us is the duration of a listing agreement. So they can't be longer than a year, and they cannot be recorded in the land records. So those are the limitations that apply to us. It didn't say anything about an extension. Our advice would be that it should, even with an extension, it should still be less than a year. Maybe that's something, if it comes up a lot, I guess, let us know. We could have our advocacy folks maybe asked to have that bill modified or that law tweaked a little bit if that becomes a problem. But the way it's written, I would be cautious. I would assume that even with extensions, it should not be longer than 1 year in duration.
All right, I had to retract my answer, Julie Shepard. I hope you picked that.
Debbie asked, when will these changes be posted on Maryland Realtors website? So they should be posted on October 2nd. And we will be sending them out to our form vendors this week. And they've been instructed to also have them ready to go for October 2nd, which is a Monday.
I see Cynthia Dunn asked a question. What if the owners don't want the increase and think they have the right to vote no? I'm assuming that's talking about the reserve study. basically it doesn't matter. It's Maryland law. You know, you might not like the speed limit, but you got to follow it, right? So if they vote no, it doesn't really matter. This is what Maryland law is required. Maryland law requires each association to get up to this funding level. Again, you can watch the other webinar. If they don't like the reserve study, I think there's a process to appeal, or they could have another company, you know, try and conduct another reserve study. But an individual owner really doesn't have a lot of leverage in these situations. Maryland law requires it. Your associations are obligated to follow Maryland law. If your officers of your association do not follow Maryland law, they will not have any coverage under any E&O policy, and there are possible, you know, discipline or possible sanctions through the state of Maryland as well. So that's probably not the answer you want to hear, but the seller, individual owner, does not have a lot of leverage in these situations.
I have another reserve question from Lisa Wary. It says reserve study requirements are on self-managed communities too. So does the reserve study apply on self-managed communities? Which is a question we do get across on the legal hotline.
Yeah.
Yeah, the only property that it does not apply to is HOAs with common areas that are valued at $10,000 or less. That's the only HOA that with the new law, reserve study law, does not apply to.
Yeah, and again, just keep in mind, the reason that was put in place, everybody was aware that that condo collapsed in South Florida, and that's really one of the reasons why this was moved forward. We don't want that to happen here, and no one wants to pay assessments. I totally get that. No one wants their assessments to increase, but at the same time, you know, if you're in a building, a condo association, you're going to have to make repairs. You're going to have to replace the roof at some point. You're going to have to do certain things. So to be fiscally responsible, the association has to have money on hand to avoid tragedies like that. So that's really where it's coming from. I know nobody wants to pay more money, but it's for a good purpose.
I see a question. How does a seller find out whether his or her property is in a forest conservation plan or not? So the only way a property will be subject to a forest conservation plan is if that property owner reaches out to, I believe it's the Maryland Department of Environment, if they want to do grading or settlement removal, excuse me, of their property. If their property is over an acre, they have to reach out to the Maryland Department of Environment and get that forest conservation plan put in place. So you wouldn't have to find out, you know, whether the property is subject to a forest conservation plan. You would just ask your seller if it is or not.
And document what your seller tells you.
Yeah.
Right. I thought there's a comment on here about the release with the new release process for the EMD. The release doesn't have an area for the seller to respond with a notarized signature. It's the request for mediation that is supposed to be notarized, not the release. So the request for mediation is supposed to be notarized. So that's why there's no notary clause on the actual release itself. Eddie Ross. Hey, Eddie. Eddie says, is the broker still required to send a traditional 30-day letter to the sellers and other broker with a new release process? No, the 30-day letter would be the old process. This might be a little bit of a challenge, I guess, for brokers and title companies, possibly, until we sort of get used to this. But there's basically two parallel processes now. The new process is if the buyer terminates pursuant to a contingency. That's when the new process would go into place. The buyer is going to send their notice of termination. The broker or title company who's holding the EMD is going to let the seller know, hey, buyer has terminated. If you want to stop us from dispersing that money, you need to send us a notarized request for mediation. If I don't receive that within 10 days, I'm going to cut the check back to the buyer within 30 days. That's the new process. If the seller terminates or if the buyer terminates for something other than a contingency, then they would still go through the old process and still could, you know, have the right to send the 30-day letter. So this is basically a streamlined process, Eddie. Hopefully it will end up being easier. You know, feel free to share input as we go through the year and let us know how it works. I think we only have a couple minutes left. You want to see any more that are asked quite a few times? Maybe we can hit the big one, the big popular ones. Oh, EMD mediation requirement effective date October 1.
There were questions regarding the forest conservation and how would you find the forest conservation?
I think I addressed that one.
Okay, and that one came across a few times. And then there was one, a couple of questions about mutual termination versus unilateral. I answered those. For those who don't know, unilateral means one side of the party has determined that they have the right to terminate the contract. So it's a unilateral. Think of a unicycle, one wheel. So one side has decided to terminate the contract. A mutual termination would mean both parties have agreed to stop or to kill the transaction, to kill the contract.
Okay.
Oh,
Someone had put a comment in here. The SDAT will show also if the property is subject to a forest conservation plan.
Thank you, Drew.
that was Drew. Thanks, Drew.
Yeah. No retired forms. We retired our COVID forms. Oh yes, we have 2 retired forms. So that's it. I think we've covered most of them. I think most of the questions were about the EMD and about the reserve studies. Again, the reserve study, honestly, there's an hour-long presentation with someone. The attorney who was on that was Karen Strawn. She's with the Attorney General's Office, Consumer Protection Division, and she's in charge of the HOA condo unit. So she's definitely the best resource. You can watch that webinar, and she provided her contact information as well. So if you haven't checked that out, that's definitely worth doing to get into the nuance of it. Forest conservation, I think we answered all those questions today. I think, and then Kelly, we're going to share the slide deck and that information with everyone who registered. This webinar will also be posted on our YouTube channel. So if you missed something or want to go back and watch this, or maybe you're an office manager, or some people in your office are with you, some people are not, you can go retrieve that from our YouTube channel and show that, watch it whenever, wherever it's convenient to you. I think we're going to, I try to respect everybody's time. I think we're going to wrap it up here. Anything else you want to add that we didn't get to, Taylor? Diamond?
I don't think so. I think we covered everything. If you have any questions, about the new forms coming out or something in this presentation, feel free to reach out to us and we can definitely answer them for you.
Yeah. We do have a legal hotline. I think everyone probably knows this. If not, you can, we have a legal hotline. Now you know. We accept calls Mondays, Wednesdays, and Fridays. The phone number 443-716-3502. It's Monday, Wednesday, Friday, 10 to noon and 2 to 4. Or if you're the kind of person who wakes up, Saturday night at 2 o'clock in the morning, 3 o'clock in the morning, you have this burning question. Diamond's cell phone number is no. I'm not gonna do that.
It does happen.
If you have a burning question at 3 o'clock in the morning, you can log on to our website and you can type in your question. And our admin, Lalika Scott, she goes through those in the morning and divides them up among the attorneys. So you can submit your question that way and then go back to sleep, and we'll respond to the question. All right, I think we are good. So thank you guys. Thank you everyone for participating. Again, reach out to the legal hotline if you have any questions. Check out the webinar on our YouTube channel. The new forms are going to be available October 2nd. And that's it. Thanks for joining us.
Great work,
Thank
team.
you, everybody.